All right, we're 2 minutes past the hour here, so let's get started. Good afternoon and welcome, everyone. Thank you so much for joining the special PIBC webinar today. My name is Tim Shah, and I'll be your host and moderator for today's session. I serve on PIBC's RPP Regulation Subcommittee, which is overseeing the Professional Governance Research and Engagement Project. Before we kick things off, I'd like to first acknowledge that PIBC acknowledges the history, languages, and cultures of First Nations, Métis, Inuit, and all Indigenous peoples of Canada. I am personally located in Victoria on the traditional territory of the Lekwungen peoples, known today as the Esquimalt and Songhees nations. I also want to acknowledge that PIBC's office is situated on the unceded and ancestral lands of the Musqueam, Squamish, and Tsleil-Waututh nations. So we're here today to talk about professional governance, a topic that was probably not top of mind for many of you even a few months ago, but has potentially significant implications for our planning profession. And clearly there is interest in the topic, and it's so great to see the high response rate with over 280 registrations for this webinar today, with a mix of member types and across sectors. Today's special webinar is just one engagement activity that PIBC is organizing on this topic. It was important to the PIBC board that we engage as many members as possible and do it in a way that meets members where they're at. That's why we're offering different ways for you to engage in this project, whether it's through today's webinar, articles in Planning West, surveys, focus groups, and at the PIBC conference itself in just a few weeks from now. And we'll tell you more about that in today's webinar. Today's webinar is being recorded and will be posted on PIBC's YouTube page. We've lots of speakers today, and we also want to leave plenty of time for Q&A. Thanks so much for submitting your questions in advance, and we're going to prioritize them. But of course, feel free to submit questions in the Q&A box, and we'll upvote the ones that you support. We'll get to them only if we have time, just given that we have quite a bit to get through today. And if we don't get to those questions, we'll try and get to them in the PIBC conference session on this topic. One final and unrelated note before I introduce the speakers. The Institute's Professional Conduct Review Committee, PCRC, has established a working group to oversee a review of the Institute's existing code of ethics and professional conduct with the aim to develop a new code. One of the first tasks that the working group has under them is to conduct a survey. The purpose of the survey is to seek the input of both members and non-members affected by or involved in the planning profession in areas such as the core values of the planning profession and feedback on the existing code. Your input to the survey will help inform the working group's review of the code itself. The survey is expected to be released on June 6th, so just a couple of weeks from now. Please keep an eye out for it, and we'd be very grateful for any input that you can provide. So without further ado, I'm going to introduce all the speakers now. First up is Deborah Jensen, who is the chair of the RPP Regulation Subcommittee. Deborah will be presenting an overview of the Professional Governance Research and Engagement Project, why PIBC is undertaking this work, and what you can look forward to over the coming months. We're also pleased to have Alayna van Leeuwen, who is the Deputy Director of the Office of the Superintendent of Professional Governance, who will provide an overview of the Professional Governance Act, also known as the PGA, which is a legislation that the province enacted a few years ago that changed the way specific professions are regulated in British Columbia. We're also excited to have two professional regulators share their professional governance journeys with us today. First, we have Christine Gelowitz, who's the CEO of Forest Professionals BC, which was one of the first 5 professions mandated by the province to transition to the PGA. Second, we have Ryan Noakes. Many of you probably remember Ryan. He worked at PIBC for many, many years. Ryan is currently the regulatory lead at the BC Society of Landscape Architects, which is in the process of transitioning to the PGA. So without further ado, our first presenter is Deborah. Deborah, please go ahead and share your screen. Thank you. Yep, we can see your screen there. Deborah, if you want to unmute yourself, be great.
There we go. Sorry, too many boxes that are showing up here. Okay. Well, thanks everybody for attending and taking some time out of what I'm sure is a busy day for you to learn a little bit more about the PGA. We wanted to spend some time to tell you a little bit about where we've started from and where we're hoping to end up. So I'm just going to go back here, and there we go. So essentially, this process started a few years ago. It's transitioned to where we are today. We have a small working group who is helping us through this process. You've already met Tim. So Tim and I are both located on Vancouver Island. David is a member of PIBC, who I'm sure most of you know, who is from Terrace. We have Gloria, who's from the Greater Vancouver area, and then Danielle, who's from the Okanagan. Recently, we also had the addition of Erica Tiffany, who has signed on to help us with this project, and she is also from the Greater Vancouver area. So we're pretty excited about working on this very complex project, I have to add. It's been a lot of work so far, and we're hoping to be able to really provide something very comprehensive and that's easily understandable by our membership at the end of this whole process. So why are we doing this now? This is a topic that has been going on for quite a while. Recently in 2018, one of our founding members, Dawn South, actually made a comment in Planning West to really say that we started looking at this back at the beginning. We wanted legislation to try to keep the bad out and the good in. So the board has decided to take on this initiative to try and take a closer look at what would professional governance mean for us. So obviously the legislation didn't take place in 1958. Since that time, there has been no legislation, but fast forward to today, where we do have our Provincial Planning Institute, who has developed some quite comprehensive processes around member registration, continuous planning, professional learning, and professional contact review, and so many other facets to the organization. We've also developed title protection for the RPP designation. So those kinds of things have come into place since that time in 1958 when we initially started. So now in 2018, the BC Professional Governance Act comes into play, and it's really looking at public interest as its primary goal. So what would that mean for PIBC, and what would it mean for reserve practice? So I do want to be clear with everybody that at this point in time, the PIBC board has really given direction to go out and talk to the membership, to engage with the membership, to gather as much information as we can as what we think that might look like for PIBC, for its membership and for the organization as whole. They have not taken a position for or against transitioning to the Professional Governance Act, and there has been no movement by the province to come to the Planning Institute and place us under their legislation either. This really is about engaging the membership. And to that end, we've been developing a work plan that would help us engage our members and continue that work for our institute. So that work plan was developed last fall, and as hopefully many of you know, all those boxes you see in the green are really some of the key pieces that we've already started working on. So earlier last year, you would have seen the first article in Planning West talking about what it means for PIBC and the Professional Governance Act. What has our history been, and where do we think we might go? We've also undertaken our first engagement survey, and that started late last year and is through into the beginning of this year. It was a fantastic response. We received over 300 responses from that, which was about an 18% response rate. So that was a really good barometer for us to see what the actual interest was in this particular issue. At that same time, in January, February, staff from PIBC began their work in talking to some of our key informants. And what do we mean by that? Well, that was talking to some of the other planning professions across the country who are already engaged in legislation that affects their organization. It was also talking to the other agencies that are already impacted by the Professional Governance Act. For example, the architects and the engineers, agrologists, and now, as you're going to learn about today, the voluntary key piece of including the landscape architects. Internally, we've been looking at gauging the other PIBC committees because there's such a crossover with some of their work plans and what we are working on. So we've gotten significant interest from them, some of them that are looking for regular updates from us, but really looking at those key pieces. How will that impact their work? Should we be included under the PGA? Webinars, here's our first one today. So we are hoping that we will have another one later on in this process. But really today is the beginning of the process and our ability to talk to you and give you some more information from some of the other regulators that are out there and from the PGA itself, sorry, their board. So you'll be able to hear more from them. We do have a conference session coming up on June 13th, as Tim mentioned already. So that will really be taking a look at as to a similar format as to what we're doing today, and hopefully incorporating some of your questions from today into that as well. So if you're registered for the conference, I'd really encourage you to attend this next piece as well, so you'll get a stronger feel for how the work is progressing. Our subcommittee, the RPP Regulation Subcommittee, we do provide quarterly updates to the PIBC board as to what stage of work that we're at. The next one will be coming up in June. And you can actually access all of this information through our project webpage, which also includes a very comprehensive FAQ section of that page. So everything you ever wanted to know about this project, everything you ever wanted to know about the PGA, please go have a look there, and I'm sure you'll find some information that will be very helpful. Some of the things that we have coming up are a strategic assessment, which we'll be looking at some focus groups as well. So we'll be taking that work on with the consultant to help us, and that will be taking a look at some educational pieces and gathering some information for us, as well as running a series of focus groups. And that's where we hope our membership will get involved a little bit more. And we'll be working with them to develop some specific topic areas. So if you're interested in being included in some of that, you can have a look and see what those topic areas will be as we continue the process through consulting with the group. We'll also be putting together an online discussion forum. So as Tim also mentioned, we know not everybody can take time out of their schedule to be able to participate in the webinars or the focus groups. So we really wanted to provide something for everybody where they could easily access this information and participate and give their opinions on various topic areas. So we will have that up and running as well, probably towards the start of the fall, once we have more information coming out of the focus groups and out of that strategic assessment. So I wanted to jump back a little bit and just give you some of the information that we gleaned out of that first engagement survey. So as I mentioned, we had over 300 responses. Some of the key pieces that we asked about and the responses we got were, number one, how would you describe your knowledge about the Professional Governance Act? So for the most part, some people had some prior knowledge. A smaller amount knew quite a bit about the PGA, but this was really good for us to understand in terms of some of the engagement pieces. We were now able to take a look at each of those activities and try and strategize as to how we were going to bring that information forward to the membership. We need to be able to keep it at a foundational level, so those people without any knowledge would be able to understand the process and then build upon that for those people who already have quite a good knowledge of the PGA. The other piece we were looking at is, so if we were going down this road of professional governance, governance and the Professional Governance Act, particularly as it pertains to PIBC and the planning profession. What else would you want to know? And through that process, as you can see from the graph on your screen, it was very high level for the most responses. What would be the advantages and disadvantages of transitioning to the PGA for the planning profession, and then specifically for PIBC itself? Following that, the next pieces that were of primary importance were looking at how would you define reserved practice, particularly in a profession such as planning, where we cover such a broad area of careers. But also looking at some of the other regulated professions, the architects, the engineers. And that's one of the reasons why I think you're probably here today, is to hear some of their experiences through this process. And of course, there are other considerations in there. People were looking at what would it mean for advocacy? What does it mean for RPP status and reserve title? What does it mean for liability insurance? And what does it mean for what our fees might look like at the end of all of this? And of course, we can't forget our planners who are working up in the Yukon. What would this look like for them? So these are some of the pieces that we have been looking at and will continue to look at through this process. And we also asked, how did you feel about the planning profession today as it's regulated in British Columbia? The majority were quite happy or satisfied with the way that the planning profession is being run today. And then another 14, 20% were not so happy or unsure about how the profession was being run. Again, this is really good information for us to know, because how would we then address this, either through the Institute as we have it today, or what would it mean as we transition through to the PGA? So as you can see from some of that, there are some emerging questions that we need to take a look at. And I can tell you that there have been many discussions through the subcommittee about some of these complex questions, and how are we going to continue to look at those and try to bring information back to the membership. So for example, public interest. Is there a risk, and what is that risk from the practice of planning for the public? And how would we address that, either through PIBC as it is today, or through the Professional Governance Act? What would it mean for reserve practice for the planning profession? We have an RPP designation now, but what would that mean as we try to encompass those diverse areas of planning and the potential intersections with other regulated professions? Is there an overlap between ourselves and engineers? Is there an overlap between ourselves and architects? These are some of the things that we need to take a closer look at. The pros and cons. What would the benefits be of reserve practice as opposed to staying within the realm and responsibilities of PIBC as it is today? Registrants and employers. Would there be an impact to them based on any requirements that might be put upon the organization through the PGA? Would it mean anything in terms of higher fees? What does that mean for self-employed planners versus municipal expenditures? And then, of course, government oversight. Is there something that we need to be aware of as far as the provincial government is concerned, and how their influence might impact the planning profession and the regulator as a whole? So, where are we going forward with this? Well, as I mentioned, we have a conference session coming up on June 13th. So by all means, please stay tuned with that. We do have another Planning West article coming out in the spring issue. So that will give you an update as where we are today. And then another quarterly chair update coming out as well. So hopefully that answers some of your questions, or at least intrigues you a little bit to ask more questions. And with that, I will turn it back to Tim.
Great. Thank you so much, Deborah, for that. Next up is Alayna. So Alayna, if you want to share your screen, please, and thank you.
Okay, and Is my screen visible to everybody?
It's good. Thanks.
Wonderful. Okay. Just give me 1 second as my speaking notes are not visible to me first. There we go. Okay. All right. Good afternoon, everybody. Thank you for spending part of your lunch hour with us. I'm Alayna van Leeuwen with the Office of the Superintendent of Professional Governance, and we are part of the Ministry of Post-Secondary Education and Future Skills, and I'm located here in Victoria. Today, I'll try to go as fast as I can and just focus on a few basics. I'll tell you a little bit about the origins and rationale for our Act and our office, and focus just on a few key points about the Act itself. So where did our Act come from? The Professional Governance Act and the creation of our office, which is an oversight office for the regulatory bodies under the Act, came out of the 2018 Professional Reliance Review. For anyone who doesn't know, professional reliance is essentially the concept of relying on the advice of professionals in making decisions, usually government decisions, for example, on natural resource use issues. So what the relationship is here, why would a professional reliance review result in enhanced professional self-regulation? It's because the author of this report saw that enhanced governance of the regulatory bodies for the key professions working in the natural and built environment would be an important input to improving public trust in the decisions made by those professionals and the advice provided to government and project proponents and others by those professionals. So the Act has been fully enforced since February of 2021. And the key principles that we emphasize are around public interest and protection of the environment and public health and safety. In terms of our office's mandate, this is something we often work hard to clarify, especially when we get complaints from the public who, or from registrants who would like us to do something different, make a different decision, overturn a decision of a regulatory body. That is categorically not our role. So we are focused on systemic and general matters. That is a mandate given to us by our legislation. And we are focused on oversight of the regulatory bodies and not the individual professionals or practitioners who actually practice the profession. We work to facilitate ministry and regulatory body relationships on PGA matters and to facilitate relationships amongst the PGA professionals, because quite often the professions that are currently under our Act are professions that often work together out in the field. We do have a lot of very strong powers over regulatory bodies. So just as one example, we review all bylaw changes proposed by regulatory bodies, and that is a really meaningful change under the PGA relative to most other statutes for self-governing professions, is that bylaw changes are reviewed and recommended by the board and not necessarily vetted through the membership of the organization. And then they're forwarded on to the province, and we review them for suitability under the Act before they can be brought into force. So that's one example of how we sort of undertake kind of a systemic and oversight-oriented role of the regulatory bodies. We also can issue guidelines, we can issue binding directives, we can conduct audits or performance reviews of regulatory bodies, and we can do inspections and investigations. Happily, that's not where we spend a lot of our time to date. We have been tending to spend it more around collaborative and capacity building type approaches, because I think it's often excellence in governance comes through capacity building rather than necessarily the provincial wagging of sticks at the regulatory bodies. In terms of the regulatory bodies that are under our Act right now, I won't read them out, but there's the list of the 6 who are under the Act presently. All 5 were under the Act when it was created, with the exception of the Architectural Institute of BC, which was added, as probably many of you might know, in February of 2023. So one of the nifty tools under our Act is that we can expand the scope of coverage of the legislation through regulations that are made pursuant to the Act. So what that means in practice is that Cabinet has decision-making authority on to bring new professions under the Act and to make regulations that set out key aspects of the profession, including their reserve practice. We also have BC Society of Landscape Architects in progress as well. I think they were the first organization to apply for a designation assessment immediately after the Act was brought into force. So they are in progress in terms of coming under our Act. So in terms of what these professions have in common, the professions under the Act are natural and built environment professions, and at least some of the people practicing the profession, their practice could pose a really direct risk to the physical world, to the environment, human health and safety. Like there is a potential for significant or irreversible harm, perhaps, from incompetent or impaired practice of the profession, of any of the professions that are under the Act currently. The other thing they have in common too, again, referring back to our professional reliance review roots, is that not everybody who practices all of these professions works in that mix, but a great number of them are involved in natural resource permitting type decisions, natural resource use decisions, and governments, including local governments, in some cases, can rely on the advice of these professions to inform their decisions. So just as an example, issuing a building permit based on architectural plans, or the necessity of environmental impact studies before allowing a mine. So for example, you might need, you'd be highly likely to need an applied biologist involved to be able to assess what the impact on native species in the area would be. Now, that's not to say other types of professions can't come under the Act. There isn't really any clear parameters or limits on that. I'm just saying that this is what the professions under the Act currently have in common. And they also frequently work together. Like it's often really necessary for engineers, applied biologists, foresters, agrologists will often all be engaged on working on the same project, because one big project can have really multifaceted impacts to consider and require sort of like iterative work on designing infrastructure, say, to mitigate those impacts. So one point, again, not going to try to do a whole treatise on the Act and all its marvelous features, but one kind of key point to be aware of is that the Professional Governance Act does have a really specific governance structure that is mandated by law. So you'd have a board for your regulatory body that would have 8 registrant board members, one of those being the past president, who would be non-voting, and 4 lay board members, or what in some contexts might be called a public board member. So that would be non-practitioners of the profession who are appointed by the Lieutenant Governor and Council. Now, that is all board members who are on the board are supposed to be representing the public interest in discharging their regulatory functions. But the addition of non-practitioners of the profession is a good way, I think, to help improve public confidence that there are people on that board who are there expressly for the purpose of considering the broader public interest, and would be less likely perhaps to be influenced by concerns around advancing the profession or the professional practitioners, personal and professional interests. Also required by the Act are 5 statutory committees, we call them, which are legally required committees that discharge the key regulatory functions of a regulatory body board. I would assume that Planning Institute already has some of these functions, maybe under different names or slightly different structures. Many other organizations under their own statutes or under the Societies Act do have very similar committee structures to this, but an interesting and key feature here is that board members cannot be on these statutory committees, and that is intentional with the view of making sure that boards are strategic in nature and moving away from the working board model that a lot of smaller nonprofits tend to have. Now, you can also have optional task groups or working groups that the board could comprise to do other bits of board business, like a finance working group, for example. But those are distinct from these 5 statutory committees. And another thing to know about these statutory committees too is that each of them must have a lay member on them, and that is part of the quorum for the committees as well. Now, this is perhaps most significant just to be aware of in terms of the point that quite a bit of capacity within the profession is needed to fulfill these functions. You need a body of ready and willing people to serve in these volunteer roles. And they are, they're pretty significant roles too. For example, like conducting investigations or conducting discipline does have quite a few important kind of like administrative fairness and common law principles around fairness and treatment and right to be heard of the registrants. That is definitely not straightforward. And then just quickly on what many professions call practice rights, we would call it under the Professional Governance Act a reserved practice. So this is an important thing to know about our act, is that our act does provide for the possibility of government to grant a reserved practice by regulation to any profession that comes under the act, but that coming under the Professional Governance Act does not automatically result in professions being granted a reserved practice. So the model that we have is that every profession under our act has what we call a regulated practice, which is just basically a working definition of what the practice of the profession is. And then some subset of that practice of the profession would be what we call the reserved practice. So we have a concept in our regulation of protective purposes. And all of our regulations have a similar structure around these protective purposes, which is really basically that it's the practice of the component of the profession where, in order to uphold the protective purposes around health and safety of the public and the environment, the knowledge and expertise of a registrant are required. Now, in actual practice, like the regulation would look a bit open-ended and open to definition. It is really the regulatory bodies have a lot of responsibility for kind of guiding and determining where that actual line is in practice between just the regulated practice of their profession and the reserved practice, which is, a set of activities that you must be a registered member of the profession in order to undertake. And so currently we have architecture, engineering, geoscientists, forestry, agrology, and applied biology all have a reserved practice. All of those other than agrology and applied biology already had a reserved practice concept in their home statute before they were brought under the PGA. So for the original smaller group there of engineers, geoscientists, and foresters, it was kind of a matter of translating their existing practice rights into the PGA. For agrology and applied biology, it was a policy exercise to define it and then enact it in regulation. And right now we are actively working on reserve practice for applied science technicians and technologists, which is fairly complex because they often work in the same kind of engineering disciplines as registered professional engineers. So we're just working through how to what policy makes sense there in terms of defining what a registered professional engineer can do versus a technician or technologist. So that is in progress. And around the reserve practice component, it's definitely a related but distinct question when considering to bring a profession under the Act is there a public interest in establishing a reserved practice? There should be a public interest rationale for granting what is effectively a professional monopoly. And how important it is to a profession to have a reserved practice defined under the PGA as well can also be considered with reference to other statutory requirements or rights granted to that profession. So like as an example, landscape architects are very frequently recognized in local government bylaws that you need to be a member in good standing of the BC Society of Landscape Architects in order to do particular tasks for a local government. So they effectively have some kinds of practice rights established outside of their home or governing statute. So Same with technicians and technologists. They are recognized under a few different regulations as being qualified persons who can undertake certain tasks. And then I'll just quickly finish off here with a little bit of a snapshot of the application and designation assessment process. I'll try not to belabor this too much because I think we do have quite a bit of information on our website on the specifics of this, but just want to give you a general snapshot here. And really the key takeaway is that there's quite a bit of a process here. It's fairly involved and it can take quite a long time from going to point of application to point of an actual binding decision here. So interested organizations can apply to the superintendent. It is also possible for the superintendent to decide of her own volition to undertake a designation assessment of a profession, but it's more common for organizations to apply. The superintendent has legal discretion to decide whether to accept or refuse the application. If the superintendent accepts the application, the next step is a designation assessment, which is basically a detailed study of the suitability of the profession for coming under the Act. It's kind of a mutual suitability examination there, the suitability of the Act for the profession as well. There are some legally required or statutory considerations the superintendent has to make that are outlined in the Act. And then we also have discretion to establish some additional policy too that we would consider in the course of doing that. When that is done, the superintendent makes a recommendation to the minister, and then the minister must consider the superintendent's report and may consider other public interest factors as well. Once the minister has made a decision, the minister would decide whether to that it is not in the public interest to designate the profession, and at which time the minister would then write a letter with reasons to the applicant. Or the minister would decide it is in the public interest and the minister will recommend it to the Lieutenant Governor and Council, or just, I'll call it cabinet for short here. And then the minister or the Lieutenant Governor and Council or cabinet is the body with the ultimate authority to actually make and enact the regulations to put the decision into effect to bring a profession under the Act, assuming cabinet is in agreement with the profession coming under the Act. And then if you want to look at the legislation, the Professional Governance Act sections 85, 86, and 87 are most relevant to this, the application and designation assessment process. But if you go to that portion of the Act, you will see the mandatory considerations that are laid out that the superintendent must consider when doing a designation assessment. And, you know, one of those being the degree of risk to the environment and health and safety of the public from incompetent, unethical, or impaired practice of the profession. We also have, you know, with the Act in force now for several years, are developing a bit more of a body of policy around it too, where we look at questions such as capacity to self-govern. Is the profession large enough to realistically self-fund, for example, through registrant fees? Are there benefits of regulation relative to the downsides, the cost to the professionals, and are those passed on to government or the public? What would be the public interest rationales for regulating the profession generally and specifically for establishing a reserved practice? Are they sort of compatible or working in the same professional mix as other PGA professions is a potential consideration? And also, is provincial supervision of the regulator for the profession warranted or helpful? Like, is there a public trust issue with the profession where it would be ameliorated or improved if the public knew that there was provincial oversight of the profession? So that's like a non-exhaustive view, but just to give you a general idea of the interplay between the legally required considerations and the other relevant policy considerations. And you can find some more information on our website if you want it, or through looking at the Professional Governance Act. It can also be helpful to look at the regulations for each profession on BC laws in the event you wanted to see how it is a regulated practice and a reserved practice are articulated in law. And I will just stop right there and stop sharing my screen.
Thank you so much, Alayna. Christine, you are up next. And it looks like a few questions popped up there in the Q&A, and We will get to at least some of those questions later. I also saw that Scott, you have your hand raised. If you don't mind, if you do have a question, just pop it in the Q&A, please, so we can keep rolling here. So with that, yeah, Christine, over to you. Thanks.
Thank you very much, and good afternoon. Hopefully I'm sharing the presentation view of my deck and not my slide notes. But thank you very much for the opportunity to share the thoughts of the forest profession on the journey we've been on coming under regulation of the Professional Governance Act. And I'd also just like to acknowledge that today I'm also speaking to you from the territories of the Leeuwen speaking peoples. So our history, kind of looking back on our profession, we were established in 1947. And so we were operating for a long time under our own act, with our own statute. And we've now had 4 years under the Professional Governance Act. So that's a long time to be under an act. And it was a very short period of time to transition under the new act and now start regulating. So looking at that process, I can see a few perspectives I could share with you. So one, policy program change, cultural shifts, and then just looking at some of the questions that were submitted in advance, capacity and cost impacts. So I'm going to take you through that. So the first thing I'd share with you is it is a lot more complicated operating under the Professional Governance Act. And a lot of the shift that was caused by the PGA was first felt internally by the staff of the organization and the board, because it required us to rewrite essentially every policy and program to align with the new direction that's set out under the new legislation. And the PGA was aiming to bring more uniformity in the way that the regulatory bodies were operating, and to limit the differences between professions. But in doing so, that really grew the amount of direction that needed to be provided in the governing legislation and all of the supporting rules that sat underneath it. So that sevenfold increase with policy complexity, what that looked like for us was, the Foresters Act and the bylaws we had were about 60 pages. Today, and pages I know is a crude kind of assessment, but today, under the current regulatory framework, there's about 419 pages that you need to know, you need to understand and interpret it and apply it into your programs and services as an organization. That's a pretty big shift, not just for the senior staff of the organization, but all of the supporting team in your organization as a regulatory body. So a lot of this is kind of going to be more impactful to the staff and the board than it is the individual registrant, but it does cascade down a bit. So in terms of thinking about what did it mean in terms of the programs, the services that we've needed to offer, for us as a regulator, we were fairly progressive over the years. We had 74 years to work along as a regulator, and as a regulator, just for awareness, when we started in 1947, we were also granted reserve practice rights and reserve titles at that time. So we had the opportunity over a number of years to be building our capacity. And so for us, we didn't have to add a whole bunch of new programs and a whole bunch of new services, but we did need to realign those, and in some cases more formalize them. So for example, we had practice advisors. We had to create that into a practice advisory program. We had an audit program, but we didn't have an audit and practice review statutory committee sitting over top of it. We had most of the other regulatory committees, but so everything required some tweaking and rewriting. What we did have the biggest kind of program differences that we experienced: mandatory reporting of 30 hours of CPD annually. And really, this wasn't a hard add for us as a a regulatory and a profession. Forest professionals, the very first year we had mandatory reporting, 95% compliance. Our forest professionals were ready for it. It was actually probably the harder work was getting the technology ready that you could report it, and not just report it, then also assess compliance and follow up on it. Another big program difference for us was the PGA brought in a new duty to report. So we've always had, as a profession, an ethical duty to report, but now we had a statutory duty which was about proactively preventing harm. And so that was new for us, and to this day, that one still, there's actually quite a bit of confusion with registrants about what that is, how it differs from the ethical duty to report under our code versus the statutory one. And it's a piece that we continue to help our registrants to understand how to execute their responsibility there. One of the other new program that came with the PGA is firm regulation. This is a huge opportunity. As a regulatory body, we see the potential for strengthening our regulatory model in the forest footprint that we have through firm regulation. But we just have not been able to garner the capacity to move this forward yet. And that's something we're trying to figure out as we are trying to get used to the rest of the work that we have to do, how we can bring that under and into work that we do. So the bigger shift, a more impactful shift for registrants, was around the culture. So, shifting, we were a dual mandate organization, so we were both an association and a regulatory body, and now we became a purist regulatory body. That feels really different for registrants. And at first it was kind of simple things that people would notice. We call them a registrant versus a member. It's now the chair of the board versus the president of the council. Advocacy, right? People are like, you cannot advocate for registrant or member interests. In reality, we never could, but we did have a very specific stewardship advocacy mandate. There's an opportunity for that to still occur under the current act, but it's about the topics and how you approach it. And so it was refinement of that, but it really felt different for the registrants of the profession. After a few years now being under it, I'd say people probably feel more the hand of regulation. When you become a registrant of a profession, some of the heaviest hand of the regulator, you feel it when you're entering the profession. You have to meet all the entrance standards, and you go through a lot of rigor in registering to come first under the profession. And then, unless you enter a complaint process where you also feel the heavy hand of regulation, you might not really notice the regulatory presence outside of paying your annual dues every year. That's very different under the PGA. Now you feel the regulatory presence through a lot more of the annual cycle. And what that looks like for us is, so for example, if you fail to report your CPD on time, there'll be a late fee. If you fail to report or pay your dues on time, there'll be a late fee and an administrative suspension that comes on pretty quickly. If you don't pay late fees, or if you fail to deliver some of your other accountabilities, the non-compliance actions happen sooner. And just the language that we have to use in how we communicate with the registrants of the profession, you can feel that regulatory presence much more stronger. So most people become a professional for the whole of their career. We have, being over 75 years old, our oldest member is over 100 years old. They've never known anything but the former act and how that was delivered. So this is a really big cultural change for some people, especially who are kind of post-career or late career, where they've been operating on a very different model for a very long time, and it just feels very different. And so just kind of related to that, you might be curious, what did that mean? Did we see a lot of people say, this is now too much burden, will I move into retirements faster? Not really. We saw some ups and downs, but it's kind of on par. Would it drive resignations? the fee increases caused people to choose when they might be ready to resign in good standing from the profession because they didn't need it anymore. But again, it's not creating a dramatic change. So just picking up the pace, I noticed my time here. On the plus side, external regulatory awareness, there is a lot of pride in the cultural shift where people really noticed their employers were paying attention, the public's paying attention. And we heard from a lot of registrants that people now understand what makes me different as a professional and differentiates me from others in the workforce. That was a sense of pride. As an organization, that awareness also led to more use of the services that our regulatory body is here to provide. So we saw more than a tripling of complaints ever since the PGA has come into force, and that's been sustained. And new for us, we started receiving complaints of unlawful practice and title inquiries a lot more frequently. So just I'm going to end on kind of what does that do for capacity and cost impacts. For us, there's transition costs. That was about 1.5 million. What that looked like is kind of explaining to the registrants what was happening, how this was changing, creating webinars, developing e-courses, supporting that. It was legal costs for new bylaws. It was a little bit of the start of some of the IT. But in terms of sustained costs, and when we started the work to come under, because 2019 is when the act was brought into force, but we had a year to transition. We're at 2.8 million, 16.5 staff and 5,500 registrants. Today, 4.3 million, 19 staff, 5,000 registrants. And we're really struggling under the weight of the new regulatory regime. In an ideal world, I'd see our budget move up closer to probably 5 or 5.5 million and increase a few more staff in order to deliver that. The other thing to manage this is technology. Unless you have a really great technology platform right now to manage your registrants, that needs to be invested in. And for us, that's looked like a $1.5 million investment. It's taking us 2 years to build it and a huge amount of time and capacity. So, and I'll just end my last slide here on the fee increases. There's a cost of doing all of this work. So for us, about 150% increase since the PGA came into force. We're about $554 for RPF in 2019. That rose to $838. And how do you deal with that? We also had to get really savvy about non-fee revenue generation. So that is through charging for webinars, being able to generate revenue from our conference, and seeking grant funding and getting really good at writing grants. So that is it for me. Thank you.
Great. Thanks so much, Christine. And just looking at the time, Ryan, I know you're the last speaker here. If you can deliver your presentation in 5 to 8 minutes, please. And thank you. Just so we have lots of time for Q&A.
Yep, I'll be mindful of that, no problem.
Thanks, Ryan.
Just gonna share my slides here. Unless anyone says anything, I'm going to assume you can all see it. So yes, I'm the regulatory lead with the BC Society of Landscape Architects. I started in August of 2023. Prior to that, I was with the College of Psychologists, going through its transition from the Health Professions Act to the Health Professions and Occupations Act. Prior to that, a brief stint with Andy Yan at SFU in the city program, and before that, 13 years at PIBC. So I'm going to rely on some of my experiences working at PIBC and some advice that I offer. Granted, it's been about 6 years, but take it as you will. So my slides are my speaking notes. They're not as fancy as the others. A bit of background about us. We were originally incorporated in 1964 under a couple of acts, which are now the Architects Landscape Act and the Societies Act. One of the things that we're facing as we go through our transition is the Architects Landscape Act will be repealed, and we will no longer apply, or the Societies Act will no longer apply to us. So It's a bit of a new territory, I think, for both us and the OSPG in terms of how do you onboard a new regulatory entity and profession where you have the Societies Act and then the Architects Act, which is a private members bill. And so there's a bit of a legal gray area that we're navigating together. It's not insurmountable. But that's our current regulatory framework. We are a federation of provincial associations with the Canadian Society of Landscape Architects as the national, very much like how PIBC and CIP and all of the others across the country operate. CSLA for us, much like CIP, is a coordinating body as much as possible, facilitating standardization of processes, labor mobility, etc. They also do advocacy work, and I'll touch a bit more on that later in the presentation. Our total membership as of 2025 is 890, so we're certainly smaller, certainly one of the smaller ones, or possibly the smallest out of all the regulators. About half are what we call full stamp registered landscape architects. The regular landscape architects are primarily those working in academia, research, and public policy. They're not necessarily engaged in what will soon to be a regulated practice. And then we have interns and pre-interns, very much similar to your candidates. The couple of things I wanted to flag around retired and student members. There's a question as to whether or not those categories should be included in regulators under the PGA, because students are not, or shouldn't be, engaging in the regulated practice. So why would you have them as a registrant category? And a similar thing with retired registrants. One of the things, an emerging issue, I would say, in regulation, not just for the PGA in here in BC, but across other professions and other jurisdictions, is what do you do about retired registrants? And in particular, those who have been retired for many years, who might no longer be up to speed on current best practices in the profession, current best technological uses. Maybe they have outdated notions of what is best practice in governance and regulation. And so as you move forward in this process, I think that's something that you should consider. It's not to say you can't have students or retired under the PGA. You might just have to limit what they can and cannot do. You have them as a registrant category, but you specify that they can't engage in the regulated practice, and then you might be fine. So again, I'm just throwing it out there as something that you think about as you move forward. And then for us, affiliates are mainly trades companies, vendors, suppliers, people who try and want to sell things to landscape architects. A lot of these are like park furniture and playground equipment companies. When we come under the PGA, we will lose that category of membership and that revenue stream because it would be seen as a conflict of interest to have that category. So again, just think about what categories of membership do you have that you might risk losing. Quick thing on our PGA journey, it received royal assent in 2019. We created a regulatory review task force, which did a bunch of research and member engagement. Consultants were hired, tens of thousands of dollars were spent. We did mandatory webinars for our registrants. The feedback at the time was, yes, we think this is a good idea, let's go for it. We submitted our application to the OSPG. They did their research. You can find, I know it's publicly available if you Google it, the Designation Intentions Report, which was the OSPG sort of evaluation of our application. And based on that, we dissolved the task force and created our PGA working group, which still exists, which is really doing much of the legwork in terms of getting us through this transition. Based on that report, following that, there was a letter from the Attorney General, which said that they will recommend to Cabinet that we be brought in, that there is enough of a public interest argument to do so. Based on that, we started to go gangbusters on doing lots and lots and lots of work. It's a lot of work. A thought or a thing, a piece of advice that I have is I think PIBC is actually better positioned than BCSLA organizationally to come under the PGA. You've got more money, you've got more staff. At an organizational level, I think your governance and your culture is mostly there, probably more than halfway at least. And so that's something to be mindful of. I know that there's other issues that I think you need to focus on your transition, as opposed to your board structure and whatnot. Because we've been putting in a lot of work and whatnot into this, probably easily couple $100,000 we've spent so far. There was concern that, well, there's no guarantee from government per se. And so the Minister of Post-Secondary Skills and Future Development, forgive me if I got that wrong, was gracious enough to provide a letter saying, no, we are committed to this project and this transition, and we will work with you. And our target date is January 1st, 2027. To officially get rid of our Architects Landscape Act, no longer apply under Societies Act, our old bylaws no longer apply, and we're under the PGA. That's a bit of a moving target. There's unknowns, and I think that's another thing that you need to think about, particularly as you get deep into the weeds of a transition, if that's the direction, is you're going to have a timeline, and there's going to be elements of it that are outside of your control. Like, I don't know, a foreign government throwing up a trade war and distracting government. And now they're like, you know what? Bringing PIBC under the PGA is not a top priority for us, sorry to say. And so things might be delayed by several months, and you're just going to have to adapt to that. So that's a bit of advice. Strategic considerations, culture shift. I said before, I think you're better positioned. The big thing is it's not about registrants first and foremost. It is about the public. And as a regulator and the decisions that are made and whatnot, it's always what is in the public's best interest first and foremost. And so I think you just have to own that, that it's not about you anymore. In terms of the relationship between public and registrants, like I said, there's more of a public protection, public interest. You're not advocating for your members anymore. In terms of the relationship between staff and your board of directors, I think Alayna and Christine hinted on it. I think PIBC is better positioned because you're going from potentially a structure where your board of directors might be much more hands-on, much more sort of a day-to-day administrative board, making decisions, whereas under the PGA, it's just really strictly focused on high-level strategy. And the day-to-day credentialing decisions, even the day-to-day operations, the board of directors is far less involved. That's my take under the PGA. And I know that some people have made some comments in the chats and whatnot around government and PIBC. You will have someone that you need to report to, and yes, government will have more influence. And again, I think you're just going to have to go into it with eyes wide open and be willing to accept that. That doesn't necessarily mean I think you need to worry about government coming in and railroading and bulldozing its way through. My experience has been the OSPG and other ministries are very mindful of consultation and making sure as much as possible that there's consensus around decisions, because these things can become very emotional and whatnot. In terms of impacts on operations and registrants, your costs will go up. Again, I think you just have to accept that. I think for PIBC, a possible thing that you need to consider is your costs for complaints and investigations will significantly increase, and I'll touch a bit more on that soon. In terms of registrants, I think at the end of the day, whether or not you have a public lay member on your committee or your board, most registrants aren't going to worry. It's how does this affect their ability to put food on the table, to find employment, to cover their housing costs. Your board might get hung up on something, but again, at the end of the day, do your registrants really care? And that will help you prioritize what you need to focus on. And then around the advocacy piece, it's a bit of a gray area. So yes, you cannot do advocacy anymore in terms of telling government that you're really unhappy about a piece of legislation or advocating about a controversial development, like, I don't know, the Oak Ridge redevelopment project in Vancouver or something. Like, yes, you're going to have to be quiet about that. It doesn't necessarily limit your registrant's individual right to freedom of speech, but they will have to be much more mindful of how they present themselves online. If your president is posting, even on their own personal social media account, well, I'm the president of PIBC and here's my personal thoughts, that's a no. But if they're on their personal social media and they make no sort of connection to their role or responsibility to the organization, there might be more leeway there. There's a lot of gray area. I was at a conference, CNAR, and I can't remember the acronym, the name, but it's a regulatory conference, and they had a plenary session where they had a lawyer moderating a couple of subject matter experts, and they went through different advocacy and posts and, okay, what falls afoul of your code of ethics and what not. So you can still do advocacy, but you're just going to be limited. And just in terms of thoughts and advice, the PGA is not a magic wand. Just if you get under the PGA, it doesn't put any onus on government or any other ministries to give you what you want and change other things. It doesn't mean planners suddenly become qualified environmental professionals. It doesn't mean you suddenly get changes to the Local Government Act or the Community Charter Act. You still have to work for that separately. Know your haters. There were some comments about the added costs to professional dues and smaller municipalities. And I think that's a very valid question for PIBC to try and answer as quickly as possible beforehand. If you're going to substantially add millions of dollars to municipal budgets, they're going to scream and shout about it. And I think government's probably going to listen to UBCM and LGMA before they listen to PIBC, because they have more political clout and people than you. So start building relationships with the people that you think would be strong allies for you. And then in terms of unintended consequences, this is something that I've been thinking about, and I think it's a question that you should, again, try and answer as much as you can. And you might not be able to unless it actually goes to court. But I'm trying to recall a conversation that I had a few years ago. So I'm going to say I had a dream where I had a chit chat with a colleague at the College of Psychologists, and they were talking about how they recognized that there was a very minor minority of people who used the complaint process as a means to stall court cases. And usually that would be family law, custody, and access of children. The court would order a psych assessment of a parent. The psychologist would do the report. The report is negative against the parent. The parent and their lawyers are like, oh, shoot, we need to strategize and figure out what to do. So they will file a complaint, a frivolous complaint against the psychologist in order to stall the court case, because now the report is inadmissible while the complaint process is going on. And so I think a useful exercise for PIBC is to figure out, could a similar thing happen if you come under the PGA? You will absolutely have controversial developments that will get approved. You will absolutely have people out there who might think, I'm going to try and use this complaint process to stall this project. And if the answer to this is yes, people could use the PGA and the complaint process to stall a development, that opens a Pandora's box of issues for you. And so I think this would be a really good question. And it might be you can do a mock trial during a plenary session at a conference. Maybe you do workshops or whatnot, articles in Planning West. But just a suggestion, try and figure that out as quickly as possible. And for time, I'm going to stop there. So thank you.
Thank you, Ryan. And thanks to all the presenters for your excellent and very thoughtful presentations. Lots to think about, for sure. So if you can all unmute yourselves, all the presenters, as we get into the Q&A here. Just as a reminder, I'm going to be prioritizing the questions that were submitted in advance. I know there's quite a few questions that came up in the Q&A. I will also try and get to those, time permitting, based on the ones that had the most votes. And then, of course, for additional questions that we just can't get to, we are going to post them to the updated FAQ, which is on the website right now. There's a whole list of FAQs, and we'll make sure we add those. So the first question I'm going to ask here, it kind of builds on what Ryan was speaking to in his presentation, is a question about advocacy. So the question is, how does the PGA affect your organization's advocacy activities and registrant services? And how does the PGA affect registrants' ability to participate in advocacy activities? And Ryan, I know you spoke a bit about that first, so I'm going to direct that one to Christine to start us off, please.
Sure, thank you. So for advocacy was a huge discussion point for our registrants, where they, because under the Foresters Act, we had such a specific assigned advocacy mandate. And our advocacy mandate was related to stewardship, and so advancing the interests of good forest stewardship. Our code of ethics actually continues that advocacy, but it's at the individual level as opposed to the organizational level. And so in terms of the registrant themselves, they still have the ability to speak out on issues that they're concerned about within the bounds of their code of ethics, making sure that, what they share is based on fact as opposed to opinion, and that they're balancing that. And so the individual is still allowed to advocate, appropriately. The difference at an organizational level, though, because we spent a lot of time talking to the superintendent, as a profession, can we still speak out about stewardship? And there's still room for that. Protecting the practice of the profession is also part of the organization's role, still under the PGA as well. So there is room in there, but it's what it caused for the foresters is a lot of dialogue about what is appropriate advocacy and what is not. And so really understanding advocating in the individual registrant or individual member interest is offside. It always was, but it really underscores it under the PGA. And so by that, what does that look like? That would look like, advocating that individual registrants like be paid a certain amount, or advocating, things that are someone's pet individual rock project. That is just offside, but there's still some room in there. One of the number one questions I keep getting asked is, well, we should set up a separate advocacy body. And the first thing I always ask people, well, what do you want to advocate about? So as soon as I would ask, like, what is the concern that you have? And in the forest profession, we have a whole bunch of different organizations. If you're worried about the economics, there's the Council of Forest Industries. If you're worried about, small tenure management, there's the BC Community of Forest Association. There is a lot of advocacy bodies that exist that advocate about that special interest. And so, the idea of having a very generalized advocacy body, I've yet to have someone really articulate to me what gap needs to be filled. That would be meaningful. So
Okay. No, thanks for that, Christine. And Alayna, do you want to add anything to that from the perspective
I just want to clarify,
OSPG?
under the PGA, the advocacy provision under section 22 is that a regulatory body may only act in an advocacy role in accordance with the Act and any rules, conditions, or limits prescribed by Lieutenant Governor and Council. The PGA, in my view, does not directly regulate individual professionals' articulation of their personal political views at all. I think that is up to the regulatory body to do in accordance, as with Christine said, with their code of ethics. And it's kind of like a judgment call then, and issues and guidance is needed around for professionals. But we are more concerned around advocacy at the organizational level. And I think Ryan's quote on his slide of yes, no, maybe it depends might be a direct quote from me, because it is sometimes a bit gray where the organizational, it is actually necessary and appropriate for the regulatory body to say something about the profession, or something that government wants to do that materially affects the practice of the profession. That's okay and appropriate. It's more just about getting away from membership oriented, kind of personal and professional advantage type activities. And we do have a guidance or a policy document about that online too, with kind of a decision tree that we invite regulatory bodies to use. And looking at that might help clarify sort of what our view on the advocacy issue is.
Definitely a really important topic, and I think it's on the minds of many members, just because in planning there's advocacy for climate change, social justice, kind of a whole range of issues that we currently advocate for. So I think it's definitely an interest of a lot of members. I think we can further explore it through this project and through this process, and I'm sure more questions will come up. But thank you for that. This next question here. So the survey results showed top interest from survey respondents in understanding the pros and cons of transitioning to the PGA. I know there's a bit of that discussion in some of the presentations, but just to ask the question, what would you say are the key benefits and challenges, pros and cons of being regulated under the PGA for the profession, registrants, regulator, employers, and the general public? So a bit of a loaded question, but I'm going to direct that one at you again, Christine, if you want to just speak to that a little bit, sort of pros and cons as briefly as you can. Thank you.
Sure. So my presentation kind of was a bit of that pros and cons, but I felt a bit guilty a bit that a lot of it was the cons. Like obviously, there's a lot more work to do under this act in terms of the regulatory burden. So the reality is it's going to cost more, and you're going to need more dedicated staff who really understand professional regulations. On the plus side, though, we're doing this for a reason, for a purpose. So if you're going to do it well. And I think the PGA sets people up to regulate well. And one of the things, as we're going through this process, we had to introduce a fairly large jump in fees 2 years ago. And it was a single fee increase of about 30% all at one time. And as I thought about, how do I send this message out? I decided I'm just going to explain what we're doing, what it looks like, and why this, like what the cost is. I actually received, not everyone loved it, of course, but I did receive a number of people who were back and said, I get it. It costs more to do things properly, but I'm okay with it because I'm really proud. Like, this is what I do every day. This is my career. I plan to stay in this career. And now my employer knows what I do and why it matters. They understand I show up differently, whether people acknowledge I'm a professional or they don't acknowledge a professional. This is how I work every day. I work to this code. I'm under this scrutiny, and I voluntarily do that because it matters that much to protect the public. That's why we're all doing that. And so I asked myself the question, if someone said, hey, if you could do this all over again, you get to choose, do you want to come under here or not? Would you do it? I would still, as the head of this organization, say we should come under the PGA, but I would have done it a lot slower. I like the 10-year lead up line that I see the landscape architects taking. And maybe, there's some things that could be carved out like that are a little bit too heavy, but when you look at the impact to the individual, yes, a $300 about increase right now to the individual, that's carried across the whole. So to regulate way better, I think it's about public credibility and public protection, and the PGA affords that more.
No, thanks for that, Christine. That was a very comprehensive overview, and you touched on something that I wanted to get at in the next question here, which is as a potential PGA regulator. So Ryan, for you, do you anticipate changing your fee structure for registrants? If so, have you undertaken any analysis of the potential effects on registrant roles and/or diversity and inclusion? If you could speak to that, because I know that's come up a little bit in some of the discussion so far.
Yeah, we anticipate our fees will go up. That's just a given. It's just a question of how much. Another big thing for us, I think PIBC and CIP are better set up for this, but right now we have mandatory dual membership with our national. So once you become a registrant to BCSLA, we automatically charge you, I don't know, $250 to $300 a year for CSLA dues. And we got a legal analysis that said we can't do that anymore. CSLA does a lot of advocacy work at a national level, and that might be seen as a violation of our public protection interests and responsibilities. And so we're looking at decoupling that relationship, and that will have significant impact for a national association because now they don't have a guaranteed membership and revenue stream, and they have to hustle and increase their value proposition. It creates an opportunity for us because, hey, we're not charging that extra $300, so why not up our fees by $200? 100 savings are passed on to the registrants, and we've got a much bigger budget. Another thing that I think, I'm not a tax expert, so go talk to a tax expert. But my understanding is once you get regulated and there's annual dues, you can write those annual dues off on your income taxes, because if you're required by law in order to be a registrant, in order to engage in the regulated practice, that's a tax deductible cost. So, that doesn't necessarily completely get rid of it, but it certainly helps mitigate the cost to individuals. And I know there's issues around DEI. I mean, I don't know how much fees will affect vulnerable populations, but I do see an opportunity here for that, which is under the PGA, anything you call a committee has to have a public lay member on it. And the CABRO, the Crown Appointment Board Resourcing Office in Government, are not involved in that process. You as the regulator appoint who those public lay people are on the committee. So there's an opportunity to convince marginalized individuals to serve on that role in your committee so that those interests are not lost. So hopefully that answers the question.
Very helpful. No, thank you for that, Ryan. Next question here. Concern has been raised about having the provincial government having direct oversight of the planning profession. What is OSPG's authority under the PGA to issue directives to the board of a regulator or to dissolve the board of a regulator? I know you spoke about this a little bit, Alayna, but I'm going to throw that one.
Yes, I am detecting a fair measure of suspicion about the provincial government here in the Q's and A's, so maybe I'll provide some slightly comforting comments, including maybe starting by just clarifying around the board composition issue. I think the way I spoke might have been misunderstood. There are 4 public members of the board that are appointed by the Lieutenant Governor and Council. The other 8 who are practitioners of the profession are elected from amongst the registrant base following a sort of a vetting process by the nomination committee, where the nomination committee can also try to select around that DEI issue. They can sort of try to select and encourage registrant members to stand for the board who maybe do represent underrepresented populations, just as one example of how the nomination committee can kind of exercise some policy discretion there. So very much the majority of the board does remain registrant board members. Now, even with the lay members, those are not the same as provincial appointees to Crown boards. Like, they are not accountable to the province as a shareholder of a Crown corporation, right? These are public and lay members. Once they're appointed to the board, the province doesn't really have a lot of dealings with them other than providing them governance training and support as needed through CABO or sometimes through our office. And in actual fact, the regulatory bodies seem to really enjoy having these public or lay members on the board because it's a great opportunity to diversify the skill set of your board. You can add lawyers, accountants, you can add representatives of underrepresented populations, Indigenous people, for example. So the public and lay members, I would say, any fears there are probably largely misplaced. Now, in terms of our role, again, we're very much focused on oversight of the regulatory body, not the practice of the profession. So we don't get in the weeds on who is qualified to be a forester, for example. Our act says you have to have a code of ethics and it has to have some different features, but we don't make up the code of ethics. That's up to the regulatory body. Like in practice, we do try to be really thoughtful around leaving leaving many of those responsibilities, and that are articulated in the Act as well, are of the regulatory body. The whole idea of professional self-regulation, or one of the merits of it, is that the profession is governed by people who know how to practice the profession, not by a provincial bureaucrat. So, so we're pretty mindful and thoughtful in our office about staying in our lane, I think, around not getting deep into the practice of the profession, who's in, who's out, all of that kind of thing. So, so that said, yes, we do have directive making authority, and directives are legally binding. And as I mentioned, we do review your bylaws for suitability, but we haven't made a lot of directives in the past, and the directives are a little bit more around procedural things. So we have a directive, for example, asking or telling all regulatory bodies to produce sort of a plain language articulation of the practice of their profession in order to help the public and others understand like what it is to be an architect, for example, and where are the boundaries of professional practice between professions. So to date, that's like, we have really not made a lot of directives at all. And yeah, I don't know if that would fully allay everybody's concerns around provincial involvement, but just to say that, you know, our Act also binds us to focus on more like kind of systemic and general matters around carrying out our oversight function.
Okay, thank you. Thanks very much for that. I know we're at almost 1:30. I'm gonna, for those folks that want to stay past 1:30, I'll do a hard cap at 1:35. Again, for those who want to stay, just so we can ask another question here and then wrap up with next steps. So like I said, you're welcome to leave at 1:30, but we'll go past to 1:35 as the hard cap. So next question here is, has the PGA affected training, education, or certification requirements for registrants? If not, do you foresee that happening in the future? Maybe Christine, do you want to speak to your experience or the experience so far of the foresters in terms of impacts on training, education requirements?
I'm not sure how our professions may differ, but for the forest profession, there has been no impact to training or education requirements for entrance. So we have entrance standards and then continuing competence standards. Nothing has shifted because of the PGA. We pretty much brought what we had and brought it in. But what I can say is different under the PGA is we have greater latitude to think how to modernize some of the things that we're doing. So the forest profession embarked on an inclusivity project back in 1996, where we set up national standards, and there's a national entrance standard that anyone across all of Canada has to meet to enter, and it supports labor mobility. But how do you modernize some of those things to be more inclusive? So right now, under the Professional Governance Act, for the first time ever, we're building out a new designation that doesn't require those same standards. It won't have the same scope and authority to practice, but we can, the new Professional Governance Act, the bylaws are easier to get through. You can redesign them. There's room to actually create more inclusivity through the Act, and it's because the profession is evolving so quickly, we see the need to do that. So we're building a new purpose-built that will allow hopefully more Indigenous people, but anybody to come in who has working experience in the forestry sector that meets a lower entrance criteria. It doesn't need post-secondary education, which every designation always has required in our profession, but we'll have a new designation that's enabled through the PGA. Has just the construct, the ability to get that through is better. So it hasn't changed anything in terms of other requirements.
Okay, no, thank you. Thanks for that, Christine. Final question here is for all the presenters in ideally 20 seconds or less. What piece of advice, either strategic or tactical, could you offer to PIBC and its members? And Ryan, you already had some nice takeaways in your slides, so thank you for that. Alayna, why don't we start with you? Just general, actually, pardon me, Christine, but back to you. Just one piece of advice, either strategic or tactical, 20 seconds or less.
Take your time, like don't rush to come under here. it's a lot of work, and if you're prepared to go under, then it'll be a lot smoother. Trying to do it in 2 years, which we did, was really hard, and it burnt out lots of people in terms of staff. So best advice, take your time and really understand the problem you're trying to solve by being regulated under the PGA. If there isn't a problem, then maybe you don't pursue it. But if there's a public protection problem, then go ahead and go forth.
Thank you. Alayna?
I like what Christine referenced with really like the policy question is, what problem are you trying to solve? Keeping that in mind. And if you were a regulatory body under the PGA, the public interest and protection of the public is at the forefront. So I think in considering whether you want to go under the act, that having that at the forefront of the discussions there would be really helpful.
Fantastic. Ryan, anything?
Like, how does the public benefit from this?
Ryan, last word to you on this?
I personally have a visceral dislike for business decisions that are based on, well, this is the way we've always done it. So be willing to let that go. Be willing to accept the change, but also understand that there are 5, soon to be 6 organizations that have gone through this process before you. So build on what they have learned. And I think you'll go through an easier process.
Fantastic. Yeah, thank you again to all the presenters. That was really fantastic. In the last 2 minutes we have, I'm going to turn it back to Deborah just to touch on next steps in a minute or less, and then we'll sign off here. Deborah, over to you.
Thanks, Tim. It's been great listening to all the speakers this afternoon. Key takeaways for me, I think, are that it is a very complex process. And so the fortunate part is that we do have a lot of time to take a closer look at this. So for us in this particular part of the project is, again, all about engagement and continuing to build on our education base. So that's what we're intending to do. Next steps, again, keep an eye out for the next Planning West article coming out soon. There will be another chair update going to the board, so you'll be able to take a closer look at that. We will be working with the consultant to set up some focus groups. So if you've got an interest in any of the topic areas, those will be posted. Keep an eye out for that. And finally, we do have the conference session coming up on June 13th. Back to you, Tim.
And that's that session is June 13th at 11 a.m. It's in the conference program if you want more details, but it's going to be, I'll be there again with 2 other members from the RPP Regulation Subcommittee. Christine and Ryan will be back. Thank you so much in advance. Back on the panel. And we're also going to have Jennifer Lawrence join us, who's the CEO of the BC Institute of Agrologists, which is another profession now under the PGA. And yeah, I guess lastly, thank you so much again to all the presenters, to the audience for being with us for over an hour and a half today. Hope you found the session useful and interesting. And like we said, this is just the start of our journey here, and there's a lot more to come. The webinar is going to be posted on the PIBC's YouTube page, and we'll send out that link in a few days from now. And thanks again for everyone for posting those questions in the Q&A as well, and we'll get them uploaded on the FAQ document. Thanks again, everyone, and have a wonderful day. Take care.
Bye. Thank you.
Thank you.